Okay. Thank you.
Sarah, I got a question. Is it pretty much like at the same time? Or is it like a delay? So it's within 2 seconds. It's not like somebody edits it before. I'm not asking.
All rise. First District Court of Appeals now in session. All who have business before this court draw near, give attention, ye shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. We have one case on the docket today, Faison versus State of Florida. Is the appellant ready to proceed?
Yes, sir.
May it please the court, my name is Luke Newman and I represent the appellant. I'd like to reserve 3 minutes of my time for rebuttal, if I might. Your Honors, my colleague for the state has filed an answer brief which states that in violation of probation, the evidence supporting any violation of probation has to satisfy the conscience of this court. I represent Mr. Faison. He's a sanitation worker. He's on child support for multiple children. He was found indigent throughout essentially the entirety of the case below. He's paid all his court costs, all of his fines. He went back and got a payment plan from the lower court and represented without objection. He essentially had 0 assets. The question before this court in this case is whether Mr. Faison can be sent to prison for failing to make a $50 copay for a mental health evaluation. Mr. Faison agreed to a sentence, a probationary sentence, in which he said he would obtain a mental health evaluation and comply with counseling. At the time that sentence, I'm talking about the original sentence, was imposed in this case, there was no oral pronouncement saying that Mr. Faison would have to pay for that evaluation.
Mr. Newman,
Yes.
Was the issue of the failure to orally pronounce the condition, was that raised anywhere below?
I don't believe so. I don't believe so. But I want to point out with that order, the order of probation that said that he had to pay for that special condition, obtaining the mental health evaluation, came out later after he was out of court. He wasn't present in court when that was said. So when I say it wasn't orally pronounced when he was sentenced the first time, it was later placed in an order of probation that came out at a later point. And the record will correct me on the number of days, but it was many days after his plea, his change of plea in court. So it wasn't orally pronounced, but the language was placed in an order of probation that came out later. And then jumping off of that, if I might, I want to jump ahead to this case, because this is something that happened the second time in this case, where if you look at the violation of probation hearing, that is what we're arguing about today, the trial court at the violation of probation hearing, Mr. Faison was originally before the court for 2 different violations. And the trial court jumped into the hearing. The state had announced, look, we're only going to go forward on one of these violations. The other one, we're not going to pursue that. And the court, in trying to keep some of the testimony in line, jumped in and said, Mr. Faison, we're only focusing on this one violation. This is only one violation that we're dealing with that relates to the mental health evaluation. We're not talking about this other issue. And then after court concluded that day, Mr. Faison was sentenced to prison, the sentence that we're here talking about today, the order of probation or order of violation of probation was entered that said he had violated 2 different, both of the issues that were before the court, that the court had personally addressed and said was not before the court. And I bring that up to show you there's this disconnect between what occurs in court. In this case, 2 different areas. There's a disconnect between what occurs in court on the record and then what's reflected in the orders that are rendered later, many days after court is concluded. Let me jump back. So Mr. Faison then comes in, he gets released from jail the first time when he agrees to probation. He gets released from jail. He asks for a payment plan, roughly the same time, his probation officer files a technical violation report. And if you look in the record, his technical violation report gives the court different options about what to do. The technical violation report also has a space where probation, the individual supervising my client, said, what should we do? Your recommendation here. And probation writes in the technical violation report, just let us to continue to supervise him. We're putting this in. We're putting this report in saying that we feel like he's in noncompliance. And the circuit court judge doesn't accept that. The circuit court judge writes back and says no.
But the trial court has the discretion to do that, right?
It is discretionary.
Probation's a matter of grace, the granting and the taking, so.
It's
that's
discretionary.
within the discretion.
Right, and I just want to be clear that when the technical violation report gets put in, the judge comes back, the circuit court judge, and says, arrest him. So he's arrested again the second time in August of 21 with a warrant. Once again, the warrant and violation report has a separate area for the probation to say, what does probation think should happen in this case? And probation makes another recommendation, and probation says, well, his probation should be modified and he should be placed on community control, which is commonly referred to as house arrest, for 1 year. All right, and then obviously jumping ahead, what happens is not that. He's sentenced to prison for 4 years. And so again, when we were talking about the disconnect between what happens in court and in the orders that get rendered later, I want to point out, for your honors, the disconnect between what probation, the people who are supervising my client, are saying or requesting, and then what the court is actually putting in, acknowledging that it's non-binding, it's a recommendation. I'm not arguing that it would be binding or that it would somehow constrain the trial court in this case. But I want to point out that separation between probation's recommendations and what actually gets done in court.
So what is the reversible error that happened?
So there are three, and there are three different errors. I want to address them in time. First of all, the order that Mr. Faison, the condition that he was said to have violated, it contained no specific timeline. It didn't say you have to get a mental health evaluation within 30 days, and do it within 30 days, you need to do it within some specific timeline. So it was a non-specific condition. He was told to obtain the mental health violation and get it at the direction of his probation officer. And I've likened this case to this court's prior decision in Jones, where Jones was, I'm submitting that Jones is almost indistinguishable. All right, it's eerily similar to what we see in this case, where Jones had non-specific order, get a mental health evaluation. He came back to his probation officer, told his probation officer, I cannot afford that evaluation. He was violated and sent to prison. In fact, Mr. Jones was violated for multiple other conditions as well, and his case was sent back for an evaluation of whether, if we deleted that violation of the many that Mr. Jones was facing, he would still have been sent to prison or would be sentenced otherwise. Mr. Faison has been sentenced to prison only on this violation. It's a standalone violation.
Let me ask you, what charges did your client plead to?
So that's a complicated question. I could answer it for you. I don't have that written down in front of me. They're of the domestic nature, and maybe there's a DNA chain between the uncertainty here, and the kind of the uncertainty we see.
I'm just wondering what the point of again, this is not necessarily dispositive. What was the point of the mental health evaluation?
I'm not sure, but let me, and honestly, I'm not sure about that, and I don't know if I could dig that out of the record for you, Judge. But let's look at the.
I mean, I know you're not arguing that the trial court could not impose that condition.
That's not an issue before the court today. And let me say this:
I'm just curious, because what if the mental health evaluation came back? And he never did it, right?
Correct.
Yeah.
Correct.
But what if he had done it and it came back and said he has this terrible mental condition? What was going to be the consequence of that?
Part of his plea would have required him to follow the recommendations of that mental health evaluation, if that makes sense.
So likely more counseling?
If whatever the mental health professional. And let me say this, Judge Thomas, if you look with a microscope at some portions of the record, there's some testimony at the violation hearing that Mr. Faison had another mental health evaluation in the past, and I think there might be a relationship there about why, since he'd had one in the past, that was a condition of the plea he agreed to in this
Well,
case.
before your time expires, you better go ahead and identify your other two reversible
Yes, sir.
errors.
Thank you. Secondly, we have an inability to pay issue, or Mr. Faison, who's been essentially throughout the whole case. Now, there's some part of the record where some judge at some point said he was not indigent, but he was indigent throughout the vast majority of the record in this case. When he went to his probation officer and said, I can't afford that, okay, then
Counsel, when did he say he couldn't afford it? At what point in the process did he first say, hey, I couldn't afford it?
So that's a good question, because there's dispute in the transcript from the hearing at when that happened. I would submit that both his probation officer's testimony and his testimony indicate that at first, when he was told to do this, he said, I cannot afford that. Later on, he was told again, get this mental health evaluation done, and at that point, he had COVID. And so there is a point in time, because I want to be completely fair with the record, where Mr. Faison said, when he was on the witness stand, he's being questioned by the assistant state attorney who's prosecuting him. I think for a while there, if you read the record, he gets it mixed up. But then he corrects himself and says, no, I could not afford that at first, and then I had COVID. And so does that make sense? If I would refer, Your Honor, to page 276 of the record, that's a transcript of the hearing, and that page of the record will contain the probation. And I'm not relying just on my client's testimony, which would, it has its own issues. I'm saying the probation officer, called by the state, said at first he couldn't afford it, and then he had COVID. Does that satisfy the question?
Yes, thank you.
So, and I want to also, we're talking about this inability to pay. Last year in 2022, this court issued a decision in Woodward versus State, which I cite in the reply brief, because it was issued close in time to the point where we filed the reply brief. And in 2022, This court, the language from Woodward said that if a violation requires a monetary component, then we get into this issue with the inability to pay, the state having the initial burden to put that on. So we've talked about 1 and 2. The third point of reversible error that I've argued to this court is that once Mr. Faison provided proof that he had COVID, he had this physical disability which was preventing him from complying. And remember, again, we're talking about not events that are happening today in January of 23. We're talking about events that happened in the spring of 2021. So we're somewhat at a different point in evaluating circumstances with the COVID pandemic. But once he provided proof and said, I have physical disability, this has prevented me from complying, that the trial court simply said, I'm not finding that credible, even though he had submitted, and there's discussion and testimony, is the state stipulating that he had COVID, or can we admit this? And he submitted a doctor's report saying, at least at this point in time, he had COVID. So those are the reversible errors.
So back to the inability to pay. So at the hearing, as soon as he raised the issue of, I didn't do it because I didn't have the funds to pay for it, what should have happened then? The state should have introduced evidence that he could pay, or they should have questioned him about?
Correct. And I'm relying on Del Val, which is the Florida Supreme Court case for that. It's cited in the briefs from 2011, which says that once the monetary component is raised, the state has the burden of establishing the non-payment was willful, it's intentional, that he had the money to pay, but he was just simply not paying it. And what I'm suggesting, to your honors, is that there's a way to read this record that makes it look as if Mr. Faison may have paid the court system to the detriment of paying probation. So when I make a big deal in my briefs or in my argument here today about how, well, his court costs and fines were paid, he got this payment plan, he paid them off, he didn't owe any money, there's a way to look at this record, and the way I look at this record and read it and suggest to you today is that Mr. Faison may have, maybe to his detriment here, paid the court system, his court costs, his fines, maybe to detriment of paying probation and being able to afford the mental health evaluation. So with that, I realize I'm into my rebuttal time, and I'll cede. Thank you so much.
May it please the court, Darcy Townsend for the state of Florida. The probation officer and the appellant both testified that there was a free option for his mental health evaluation that appellant knew about. The judge found that the probation officer's testimony credible, and the existence of a free evaluation refutes all of appellant's arguments here today because the state didn't have to prove ability to pay for a free evaluation. There was no error for the court not announcing the cost of a free evaluation. And the COVID was not an issue because appellant also concedes in his brief that he was healthy enough for an evaluation at one point in time, and then he could not pay for it. Appellant says on page 6 specifically of his reply brief that Faison testified that at first he could not afford the evaluation. Later, when he was directed again to obtain a free evaluation, he was ill. Faison and his probation officer give the same testimony that he at first could not afford it, the evaluation, and was later ill with COVID. As for the COVID, the only credible evidence that the appellant ever had COVID was the test from August 12th, and at that point, he had already been violated on probation.
So you would concede there's a discrepancy between the written probation order and the oral pronouncement, correct?
It was not pronounced at his violation or at his sentencing hearing, but it didn't need to be, especially when he knows there's already a free evaluation available.
But, in reviewing the reports from the probation officer, it seems like she called him up and directed him, you have an appointment at CARE, you need to go, this is your appointment time. And, if his understanding was I need to do what my probation officer says, if she's directing him to go to CARE and they're requiring the $50, isn't that she's kind of ordering him to go somewhere where he's going to have to pay?
She had advised him to go to CARE, but she had also testified at the violation hearing she would have accepted the life management, and he knows that that's an acceptable evaluation because he has experience with the system, he's already been on probation before, and that evaluation was acceptable in his earlier case.
So the trial court essentially found he just refused to go to the evaluation?
Yes. And that, it really comes down to a credibility determination by the judge. And the Russell decision that I cited in my brief, the Florida Supreme Court has said the trial court can take into account credibility of witnesses, the defendant's experience in the criminal justice system, and evaluate the evidence before it. And it comes down to the court's discretion and credibility determinations.
Counsel, I think pardon me if I'm putting words in your mouth, but I think I heard counsel previously suggest that we might disagree with the trial court on a question of credibility. What is our authority to do that, if any?
There has to be competent, substantial evidence to support the judge's findings, but this court cannot go back and reweigh the credibility of witnesses. It's the trial court's decision.
And that rule only applies with live testimony, right? When a trial court makes findings based on deposition testimony or written evidence, our standard of review is de novo. We can review those documents as well as the trial court. But if he makes a credibility determination based on live testimony, that's a different standard.
I believe this court has to assume that he reviewed the record before him and took into account everything before him, but
I mean, did the trial court rely on any kind of written records that you know of? Or it was just a determination that based on his testimony and the probation officers, it was a willful violation and he refused to go to the treatment?
we only have what the trial court announced in his ruling.
So reading what the trial court announced in his ruling, the testimony is, and this is reading the transcript of the court's findings, the testimony is that it was only after he was ready to be violated that he began to claim the indigency status with Ms. Purvis. That's the record evidence I have. But if you go back to Ms. Purvis's testimony, it's pretty short and sweet in discussing, she had directed him to complete his evaluation. Okay, when you informed Mr. Faison to do that, to complete the evaluation, did he ever tell you why he was not doing it? He said he had to reschedule because he didn't have the funds. And then he said that he was going to go through life management, and it wasn't until I told him he was going to be in violation, that's when he came up with he was sick for COVID. So it seems like her actual testimony is the reverse of what the trial court said the record evidence was. He said he didn't claim indigency until she told him he was going to be violated, but her testimony, it's the opposite of that.
He may have
So
gotten that.
even ignoring everything Mr. Faison said, based on the credibility determination that the trial court said he wasn't credible, if we only hang it on what she testified to, is that CSE to support a finding of willfulness?
He still had, the fact that he had a free option undercuts all of that argument because he still did not get the evaluation done. And he had a free option to do it that he knew about.
But again, if his probation officer is telling him you need to go to care, he keeps rescheduling through care, and based on her reports, he communicates, I don't have the funds, I'm rescheduling because I don't have the money to pay. And she told him, well, just reschedule again, you'll have the money by the time the appointment comes around. So she's continuing to direct him to go to care. So at the hearing, when the issue of he didn't have the ability to pay for care came up, what's your response to Mr. Newman's position that the state had the burden at that point to show that he could pay under Woodward and Del Val?
Under Del Val, that burden's met. Both he and the probation officer testified that he was working. That's sufficient, and at the time, that's sufficient to shift the burden under Del Val. Still, that he has to show the inability to pay. What it says is that after evidence of willfulness is introduced by the state, the burden may then properly be shifted to the probation and truth cert and prove inability to pay.
He had
which didn't.
testified, yes, I'm working, but I'm paying child support for 4 children. I'm on a payment plan to pay back my court costs. My paycheck is not, I'm getting a paycheck, but it's not enough to add in a $50 cost. And when Ms. Purvis was testifying, she said, yes, he was employed at the time. And when she was asked, was he employed in such a capacity that he would no longer be considered indigent by the court, she said, I cannot answer that. So, yes, he was employed, but he offered reasons why his paycheck wasn't enough to cover the $50 cost.
But it still comes back to, yes, she had advised him to go to CARE, but he knew that there was a free evaluation that would have been acceptable to the court. And
Well, I
he
guess
did, and
the
he
que-
still did
I-
not comply.
I guess the question by my colleague is, he says, I'll go to life management, but the probation officer testifies, no, you go to CARE. You have to go to this entity that charges. She did not say, oh, life management, good, that's free, you won't have to pay a copay there, you can go there.
She had also never told him that he couldn't go there. She had only told him that he couldn't, he had tried to
Right.
turn in this old evaluation. She told him that he couldn't do that. He needed to get a new evaluation.
But that goes to willfulness, right?
Yes.
So she told him, you need to get a new one. You have an appointment at CARE on March 30th. You need to be there. Here's the phone number. Call, go there. I mean, that seems, in his order, at sentencing, he was directed, you have to get your evaluation at the direction of your officer. So there's just some gaps here that, we're trying to determine whether there's enough to uphold the finding of willfulness, and there's some gaps here.
It's still going to come down to the credibility determination by the judge. He was told multiple times to do it and failed to do so, knowing he had a free evaluation, and understand there are, and his testimony about why, it was still for the judge to determine whether or not his testimony was credible about why he couldn't get it done. And he still knew that there was a free option available that he wasn't entitled to rely on. Like, he still knew that it was acceptable by the court.
Counsel, let me ask you a question about the Jones case,
Yes.
which the appellant relies on as being similar. In the Jones case, did that parole officer provide direct directions to the parolee? Is there a material factual distinction there?
Reading the Jones case, there is a difference. It appears that probation officer was not in touch with the defendant, and had only spoken once, gave a bare minimum recommendation on what to do, and then didn't violate until later. In this case, you have a probation officer that is in touch with the defendant and provides advice, but he's not communicating back with her either. He's rescheduling. She's finding after the fact that he's rescheduled it and not followed directions or asked further questions or been in communication with her.
But in this case, the parole officer did tell him that he needed to get the evaluation ASAP. She told him that early. And she said he didn't raise inability to pay until after he was violated. Is that my understanding of the record correct?
She had said he said he couldn't pay, and then later it was COVID.
Was her affidavit different from her testimony, though? Or her written document in support of the VOP? I'll look at it.
She did say in her affidavit, there was that she had told him to get it done, then he had missed his appointment. And then there was another instance where he said he couldn't afford it, and then she said, go ahead and schedule it, which he did not do. So he had still not completed it.
In your answer brief on pages 2 and 3, where you quote from the violation, technical violation notifications, dated June 22nd, in it, the officer notes that the offender did not attend the mental health evaluation due to not having the funds for his copay. And then later in the full, you quote more of it. The July 27th warrant and affidavit on page 3 of your brief, you quote that he also mentioned it. So in the reports and the notifications, there are references to, he's saying he didn't do it, he's saying he rescheduled it due to his inability to pay, and then in her actual testimony, she says, I directed him about 4 times to go get it, and he said he had to keep rescheduling because he didn't have the funds. That's on page 276 of the record.
It still comes back to that he had an option that was acceptable, that he didn't pursue until, I believe he said that he tries to schedule it for right before he's violated it again. He's already missed several, rescheduled again, and missed several appointments.
And then once he's finally told, okay, this is it, you're going to get violated, then he gets COVID, and he actually shows up with proof that he had COVID, because her testimony said he did.
Only for
provide
that,
proof for that final warning time period, correct?
correct. It doesn't explain all the months before that he had failed to follow directions. The state asks you to affirm based on the arguments today and arguments in the brief. Thank you for your time.
Thank you.
Judge Nordby, I wanted to go over and I think you hit on this towards the end of the argument just now, and this goes back to what I was talking with Judge Kelsey about earlier, just the complete quote from Ms. Purvis, the probation officer, in which he said, it wasn't until I told him he was going to be in violation, that's when he came up with he was sick for COVID, and then provided me proof that he was sick for COVID. And so I just wanted, and that's again, Judge Kelsey, we were talking about this earlier on page 276. That's why I referenced that.
Let me ask you,
Yes,
why
sir.
didn't he just tell us, probation officer,
Yes, sir.
why don't you just let me go to life management and not pay the copay?
I think that this all comes up from this discussion that happened at the hearing, when at the hearing he's trying to explain how this went down, and I think that he says he was trying to get set up with some free option. So there's this notion that there's a free option, but and I don't know if it was ever, I don't know if Ms. Purvis ever said at the hearing he had a free option. If the transcript corrects me on that, I apologize in advance, but I think this comes from him articulating on the witness stand that he was trying to work some other free option. And so I think that's where all of this comes from. But when we talked earlier with my colleague from the state, and we referenced back to these sections of the transcript that are contained in the answer brief, it seems to me that Ms. Purvis keeps instructing him to go to this care place, when the care place is the place with the $50 copay that he said from the outset that he couldn't afford. And so that brings us back a little bit to the judge's, we're looking for competent substantial evidence, we're looking at the judge's credibility determination, and I think we dealt with this a few moments ago. But what the judge said was just wrong. I mean, the judge got it backwards. The judge said he had been threatened with a violation, and that's when he started talking about being indigent. But what Ms. Purvis testified to at the hearing was that he was indigent from the get-go, from the jump. So that's what I wanted to address on rebuttal. If there are no further
He
questions,
should have saved $50 from his court costs.
that's my legal advice. In back in time, legal advice. Yes, sir. I'll submit the case on behalf of Mr. Faison and rest on my briefing. Thank you so much.
Thank you. The court is in recess.
All rise.